Um, Thank you so much for joining us for this next in our series of workshops and education and support offerings that the nonprofit United Policyholders is offering through our Roadmap to Recovery program. Today's topic is options and remedies for the underinsured. And my name is Amy Bach, and I am so pleased to be with you today and to be joined by a special guest. We're going to be covering self-help approaches to getting an insurer to retroactively reform your policy limits and pay over the limits that are stated in your policy. We're going to talk about what the Department of Insurance, the California government agency, might or might not be able to do for you if you are underinsured. And then we're going to be talking about what a lawyer can do to help an underinsured wildfire survivor. A little quick bit about United Policyholders. We are a nonprofit. That's 501c3 is the fact that we're tax exempt. And because we serve in a public purpose, an educational charitable purpose. We are a voice and an information resource for consumers in all 50 states. And we're very proud of our 30-year track record. This is our 30th year of serving wildfire survivors and being a subject matter expert on insurance and disaster recovery. We are not for profit, not for sale. And we say that because we do not accept any funding from insurance companies so that we can have an independent voice and give you information that's in your best interests. We're funded by donations and grants, and a lot of our work gets done by a volunteer corps of people with either personal experience having gone through a disaster or professional experience in counseling disaster survivors with regard to insurance. And we also have a professional staff. A little bit of fine print. This workshop is intended to be general guidance only, not legal advice. We don't endorse or warrant any of our sponsors or speakers, but they are here. I am here, our guest volunteer speakers here as an educator. So even though he's an attorney and I'm an attorney, we're not here to be your lawyers. But we are going to give you a chance to, if you feel like you want to sit down with an insurance lawyer, I will at the end of the program tell you about a clinic that we have coming up, a pro bono legal help clinic that you might want to register for. So this is the homepage of our website. It's there for you 24/7. Uphelp.org. And then this is the library that we set up for all the households across California, northern, southern, east and west that were impacted by last year's bad series of wildfires. So we just put you all together, 2020 wildfires. So we didn't break it out by the name of the fire that affected your household. But all the information that we're bringing you is relevant if you live in California or you own property in California. So you'll find in the library that we put together for you all kinds of help publications, and they're organized in a timeline according to when you typically will encounter problems, or you'll have questions at the different phases of your recovery process. And people often ask us, how do I keep putting one foot in front of the other? How I feel so overwhelmed, so many decisions, and I'm exhausted. I'm not getting sleep and all that. And what should I do to get out of this feeling? And we always say, think of it as a process, and you just have to take it one step at a time. Just like anything that's challenging, don't try to take everything on at once, but just take one piece of it. So tonight we're going to be taking one piece of it, which is, what do you do when you find out you don't have enough insurance to put that house back that you had, or you don't have enough insurance to replace all of your outbuildings or your contents. So we're going to, so there, the library, we've curated for you links to professional help, we have sample letters writing a good, clear letter to your insurance company and asking for them to remedy the fact that you're underinsured. We have tips from people who've been there, done that, walked on the road you're on now, got through to the other side, which you will too, and are paying forward the help they got by writing tips and contributing to United policyholders guidance, so that you're getting guidance from professionals like myself and our guest Ben Suter, as well as you're getting guidance from regular people like you who maybe knew nothing about insurance, don't want to know anything about insurance, but sort of had to learn the hard way, and they contribute some of their advice. That's all of this is available for you in this library. That's me. I've been dedicated to advancing the interests of protecting insurance consumers since 1984. I'm an author. I co-wrote the Little Yellow Recovery Handbook. I've written a lot of the publications on our website, and I co-founded United Policyholders. So I am fortunate not to be in that, what people sort of try to jokingly say is an exclusive club of people who've lost their homes. I'm lucky I'm not in it, but I have spent so many years with people who are in that club, and who that I feel that I have a pretty good organic understanding of how challenging it can be to try to really feel like you're getting a fair shake with your insurance. And there's so much unfamiliar language, and the processes are definitely not as consumer friendly as they should be. The whole process is more complicated than it should be. But we're here to break it down for you. We're here to make it simpler for you so that you can really understand it. Because unlike your insurance company, we want you to, on some level, question things that your adjuster may say that don't sound right. So I really want to thank Ben Suter for being with me today. Ben is a shareholder with a law firm called Kiesel, Young and Logan, and in its San Francisco office since 1987. He's an experienced business litigator, and Ben has successfully helped underinsured wildfire survivors reach confidential settlements. Ben, thank you so much for giving us some of your time.
Thank you, Amy. It is my pleasure, and I so admire what you've done over the course of your career and how you've helped people for decades here who really do need the help. And you are spot on when you say the system is way more complicated than it should be, and it's very difficult to navigate. So in fact, my clients who I've helped all started with United Policyholders as a reference point for them to be able to better understand what their rights were and what they needed to do or not do when they're in a state of shock and have lost everything. So your work is so profound and so commendable, and I'm honored to be chatting with the same group of folks as you.
Thank you. And I want to also thank our funders that are making it possible for us to bring you this workshop series and all the other offerings that we're bringing to you in the aftermath of the devastating fires from last year. So what are the big 6 challenges that are typical obstacles for wildfire impacted households? Number 1, underinsurance, not having enough coverage. Number 2, valuation disputes, where the insurer says this is how much it'll cost to put your house back, and a builder says that's not correct, that there's a different number. Home inventory is right up there. Putting together an itemized inventory of everything that you lost is definitely one of the big challenges, and we work very hard to help you get your insurer to agree to reduced itemization. Like you don't have to list every single spice by name, but you could just say 50 spice jars, that sort of thing, or books. But again, that's, some insurers are can be really sticklers on it, and So that's one of them. Another one is the challenge of deciding if you actually want to put back or feel like you even can go through the construction process to rebuild your house, or whether you want to just buy elsewhere. And those kind of decisions can be very challenging. And then, of course, what insurance benefits are available to you and when the money will be released to you. And finally, the very common challenge where people will have one adjuster assigned to their claim right after their loss, and then that person will leave after a few weeks or months, and so a new one will come in, and we call that rotating adjusters, and that is a chronic challenge for people because you don't want to have to start from scratch if you've gotten things rolling with an adjuster and have agreements, and then somebody new comes along. So those are kind of the big six. And for each of those, solving each of those obstacles, these are the main paths. Negotiation, which is another, we also kind of call that self-help, just negotiating with your insurance company. Mediation is another one. That's a process. It's generally an informal process where you have a mediator that's in between you and your insurance company trying to bring you together. There's another process called appraisal for resolving valuation disputes. There's legal help, going to somebody like Ben or one of the other attorneys in our Find Help directory, or filing a complaint with the department. So really depending on what the problem is, that's kind of a chart of your options. With regard to underinsurance, you can certainly try mediating underinsurance cases, and people have. But most people find that the most effective way to remedy underinsurance is by either negotiating on their own or by hiring a lawyer. And even a lot of the people who've negotiated on their own either are lawyers by trade or they got help from a lawyer. It's very much of a legal kind of a thicket. So just underinsurance by the numbers. We do surveys after disasters, and typically the number it's incredibly consistent. 2/3 almost every time of the people, 2/3 of the people who complete our surveys report that they were that their dwelling was underinsured. And you can see in one survey, the average amount was huge, a $367,000 gap. And then in another one, the average was $163,000. So we're not talking about a small problem. We're talking about a big problem. So getting an insurer to pay more than their contract says they owe you is not easy. I got to put that right out there. But although a contract is a legal written document, there are invisible terms that our laws add to them to make sure those contracts are enforced fairly. And every insurance policy sold in the state of California has an invisible clause that the insurance company must act in good faith and deal fairly with you. And finally, insurance companies and their agents cannot deceive or mislead you. They have to live up to the promises they made. So Ben, those are kind of general statements. I kind of wanted to zero in on number 3. The term good faith and its opposite, evil cousin, bad faith, get thrown around a lot. And, I'm curious to ask you, in representing underinsured homeowners, did you use those terms much?
I used them in both cases that I recently did. I had a specific cause of action for a breach of the covenant of good faith and fair dealing, but I didn't hurl it about in every discussion with the other attorneys. One of the things about a bad faith claim or a breach of the covenant of good faith and fair dealing is there has to be an underlying breach of the contract in order to support the bad faith claim. Much of what I've been able to do, and frankly, that was effective with the insurance companies, is to focus on factually what information they didn't provide to the insureds, and to demonstrate that there are a whole bunch of different specific provisions in the insurance code and in the law in general that make them nervous that they didn't actually comply with that. So my approach dealing with insurance companies and their attorneys is to politely approach the issue, to not bang on my fist on the table and yell bad faith and punitive damages. It's, let's demonstrate to you what you didn't do, what you told my folks, and what's in your own file. And it's what's in their file that often will determine whether an insurance company has acted in bad faith or not.
That's really helpful, as I think that our organization focuses on giving people really practical guidance, and that is that insurance is a technical kind of an area. The policy is a legal contract, and the best way to get what you want is to be specific. And when people say when people throw the terms around bad faith, they think it's going to maybe scare the insurance company, but in my experience, that's not the case, right? Words don't scare them, but facts do. Is that would you say is a fair statement?
Oh, absolutely, absolutely. And they know when their own conduct is either getting close to the line or has crossed the line. And I find that the more you focus on the facts once you're in litigation and demand facts from them, and demand the underlying policy manuals and their standards of conduct and their code of ethics, and you compare that to what's done, often there's a chasm, and that's what scares them.
Mm-hmm, mm-hmm. Okay, so a couple of pointers for those of you in the audience who haven't already done this. Because underinsurance is such a chronic problem that our organization has been trying to help people solve now since we were formed, we do have quite a bit of information on our website to help you, especially if you're having trouble sleeping. Some of it is pretty darn dry. But it's pretty thorough. So you can use that little the search box, which you get to through that little magnifying glass, and just type the word underinsurance in, and you'll get to this article. You'll get to all kinds of things to help you. So the basic reason that many people are underinsured is that the dwelling limit that was placed on their the policy limit that was placed on their dwelling is typically the category for your dwelling coverage. The insurance on your home is labeled as coverage A. That limit was set too low when you bought the policy, or it was accurate when you bought the policy 20 years ago, but when the policy renewed each year, whatever little inflation factor the insurance company was applying didn't bring it up to current costs. Now, we're not going to go into a whole lot of detail about the endorsements. If you had the add-ons that might help you, extended replacement cost coverage or building code coverage, but those add-ons help you not be underinsured, but a lot of people find they don't have those either. That their coverage A limit was set too low, and they don't have code upgrade, or they don't have extended coverage. But some people find that they're underinsured even if they have extended coverage and code upgrade coverage, just because the per square foot building costs in their region, especially after a disaster when there's high demand, limited supply of materials and services, prices do go up. But insurance companies know that. They're supposed to, they should have fixed this a long time ago. And I think there's reasons why they don't. I think, I don't know, did you get into any kind of real understanding, Ben, of why insurance companies continue to underinsure, even with all the fuss and bother we've made?
I do, and it may sound a bit cynical on my part, but insurance is sold on the basis of cost, and it's sold on the basis of how quickly you can get a homeowner to agree to go with your particular company. I think the insurance company as a whole, as an industry, try to get the lowest price and have the lowest amount of coverage there that they can get away with, frankly. And one would say, well, that's counterintuitive. Don't they make more money if they have higher premiums for more coverage? Well, what they want is to get in a sweet spot where they get what is facially, at one point in time, perhaps the right amount of insurance for the lowest cost. But by having a lower coverage A, they end up, when there's a disaster that strikes, being way better off, because if they insure a house for $335,000 instead of $750,000, they can say, well, look, we entered into a contract, you agreed to that, you're the person that had the choice, it's your responsibility to figure out how much you want to insure your house for, we're just providing a service. And when disaster strikes, they save millions and millions and millions of dollars, in my opinion, by underinsuring. And they will always say this in their literature and their documents that follow up. You chose the amount of insurance. You're the one that's responsible for this. It's generally in relatively small print, and adjusters throughout the process continually say that. That's not what happens. The company's computers determine the amount of coverage, and they usually do it in 20 minutes or less. It's astonishing. They try to provide this information. Sometimes there's follow-up, and there are good companies out there that do a better job than others. But the name of the game, in my experience, defending or representing folks that needed to go against their insurance companies, is that the amount of coverage provided was determined in every case by the company's computers, and the courts know this. And frankly, I think there's starting to be a bit of a turn in the tide on that issue. But I'll save my words for now because I don't want to interrupt the flow of your presentation here.
No, that's okay, because I was kind of hoping you'd say that, because I feel like, for the 2020s, the folks that just lost their homes last fall, we always want their path to be easier than the last group of fire survivors path, because as we go along, we try to fix things as much as we can. This has been a stubborn one. So I'm hoping that we're making some progress and that the courts are starting to get this. But the current law still doesn't fully reflect reality, right? That the courts they say that the insurer only has what they call a general duty to procure insurance. But that they don't have a duty to advise an insured as to the adequacy of their coverage or the availability of other coverages. We know that is a little bit nutty. I mean, I think it's nutty, because in reality, insurers and their sales reps represent themselves as experts, and they're the ones that set the limits. I never met a person ever that walked into an insurance company office and said, I want $400,000 of insurance on my house. I'm sure there are people somewhere out there that did that, but the 99.99% of people logically assume, here's somebody that sells insurance, and here's an insurance company that is insuring homes and paying claims all over the country every day. They know what it costs to put a house back. I don't know. I'm not in the construction, industry and all that. But of course, people do use that logic. Like, well, wouldn't they? If anything, isn't my insurance company going to try to sell me more than I need, so to get more of my money? That's a logic, but it doesn't apply here because of what Ben said, that the insurers, the insurer and their agents are focused on making the sale. They're focused on competing, and they want to limit their payouts. But there are some exceptions, which is why Ben has been able to get some success for his clients, and why quite a few of the people that United Policyholders has worked with over the years, has educated, have been able to remedy their underinsurance, but it is almost always in a confidential settlement behind closed doors, and the insurance company insists that you not share that information, which is very unfortunate, because a lot of what we encourage people to do is share information with each other. But there are things that people will be able to tell you about their settlement without giving you the exact numbers and that sort of thing. So what are the exceptions in the law that allow you to hold an insurer or an agent or broker responsible for the fact that you don't have adequate insurance? One is whether if they misrepresented the nature, scope, or extent of the coverage. Another is that they failed to obtain what you asked them for. And another is if they took on a special duty above that general duty to just get insurance for you. If they said, if you can show through evidence that the agent, broker, or insurer said to you that you had a conversation with them and you said, gosh, I just remodeled, I want to make sure I have enough, or my neighbor, I read about people in the fires not having enough insurance, and I don't want to be one of those people, God forbid. And the agent or the insurer said, okay, I'm going to increase your limits. And then either they didn't or they did, but you need proof. And so this is the problem. We've been doing these workshops, as I said, for 30 years, and people always say, and I believe you when you say this, that I did ask for an assurance that I was adequately protected, and they assured me that I was. And when the problem is, that's what a court would see as a he said, she said in a lot of situations. And if you have no proof, no records, no emails, no phone logs, no notes, nothing that is proof, and it's just what you're saying, those cases typically do not go very far. Unless you have some kind of strategic approaches. But even the cases where lawyers have been going after the computer programs, that, for example, that the agents and brokers use at the point of sale, even those, we still don't have good published law. So many of those cases get settled out of court. And I'm going to show you an example of that a little bit later. So what are the strategies that we recommend?
Excuse me, Amy, can I make just a couple
Yes,
of quick points?
please.
One on the expertise, what a client or prospective insured expects from the insurance agent or broker. In California, agents have to specifically take a course on underinsurance. So it's absolutely clear they know that this potential problem exists, but the general consumer does not. And that gives more of a basis for insurance professionals to be held liable, because they've been specifically trained in this area and they have this sort of expertise. The second quick point I was going to make related to the he said, she said. Some insurance companies record initial conversations with their insureds, and they do that presumably to protect themselves. In a case, a recent case that I had just handled, the agent said, we will take care of this. We'll get you what you need so that it all gets rebuilt. And that was a constant theme in our case. Was it's recorded there, whether it was authorized or not, it's another issue. But when the agent, told the clients directly, and these were brand new clients, we will get you the insurance so that it all gets rebuilt. What's the client to think? So I just, again, I apologize for interrupting, but these are little anecdotes that are perhaps helpful for some of the folks that are listening or who may listen to this down the road.
And it fits, Ben, with a question that just came up from Christopher. Is it possible to compel your insurance company to provide that recorded transcript of the phone conversation that took place when they set the policy?
The answer is yes. Mostly that should come automatically when you ask for it. But some insurance companies are reticent to give out information beyond what's specifically required by the California Insurance Code. But they do have a duty to preserve that, and one will get that eventually, hopefully sooner rather than later.
Thank you. So yeah, the game here, it's not really a game. The play book is to find and use leverage to convince your insurer to pay above the limits, right? So one basis, did they give you reason to believe your limits were adequate? You just heard Ben give a very good example, a clear example. Did they undertake the duty to set limits adequately? Again, in Ben's example, the agent said, I'm going to make sure you have enough, or words to that effect, to rebuild your house. And then technically what people often ask for is a retroactive reformation, and where you say, okay, I'll pay the difference in what my premium would have been if you had insured me properly. Ben, did your clients have to do that, or was that not the basis?
Yeah. In every case that I've handled, I've insisted on reformation. I've obtained reformation, and we've never had to pay the difference in premiums, which is a roll of dimes compared to the difference in coverage. So yeah, reformation is a key issue here in all these cases. And maybe later on, if we get more time or get more into the weeds here, I can share with you a few reasons why reformation is absolutely necessary to maximize the ultimate recovery that a client gets.
Okay. And I know there's different ways, to sue. You can sue as an individual or as a group, or you can, there are class actions that take aim. I've seen them go on for years and years and years. It seemed like, would you say that the individual approach is the one you generally recommend?
I'm right now considering bringing a class action. I've spent months going over the underlying facts and trying to make sure that it would be a wise thing both for the client and for frankly, the general public, if there's a benefit that could be secured. But most of my cases, in fact, all of my cases have been individual cases, and frankly, that's what I feel my obligation is to first and foremost, is to help, the poor folks that have had to deal with the incredible loss, and not just of all their possessions in their home, but the emotional toll, first of all, of losing that, and then having a second crisis or a second horrific event to deal with, which is an insurance company that's less than cooperative. And again, there are some very fine folks out there, I'm sure, who do their level best to help. There are certainly others that apparently think that their goal or their job is to minimize the amount that the insurance company has to pay out.
Okay, so we did get another question, by the way, that was asking about if you have guaranteed replacement coverage, how does that factor in? And, guaranteed replacement coverage is a form of coverage that we thought was had become obsolete. It was around after the Oakland fire. It basically blows out whatever stated limits are in your policy. If you really do have a guaranteed replacement cost policy, we'd love to have you get in touch with UP. Send it to me, amy@uphelp.org. But it in theory, if you have guaranteed replacement, you should not be underinsured, as long as it's being applied properly. So here's the self-help steps that we recommend for you if you are underinsured. First, check your policy for obvious errors. Pretty common, the insurer may have the wrong square footage or even the wrong address. If you can show that the mistake wasn't your fault, you have a much stronger case for increasing your limits to where they should have been. In order to really know how underinsured you are, you do need to get a rough or a reasonably accurate estimate to rebuild, as was what your home should have been insured for. In other words, what it's costing, what it is costing you to put it back, or what people are estimating for you it's going to cost. And that is that's something that we recommend. You can get help from a builder. You can go to a construction estimator. We just did a workshop last Saturday on if you want to take the estimate that your adjuster has given you and use that and just fix that and make that accurate. There's lots of different ways to calculate the as was, but it is an important step. Reviewing the history of how and when your dwelling limits were set. This is a tough one for most people. We don't remember. Most people don't keep great notes, you know, but if you have them, and then they might have been destroyed in the fire. So this is one, you know, but if you remodeled, or if you refinanced, or if you switched agents, that might help trigger your memory. So you can look at your phone records. Did something trigger you to contact your insurer to seek reassurance? Did you get that reassurance that your limits were accurate? What do you have in writing? Emails, texts, letters? If possible, seek out and compare notes with other property owners who are or were underinsured by your same agent or insurance company. And that's something that can be, it's easier pre-COVID when we were doing live workshops and you could meet other people in person. But we have our survivor to survivor forums that you can use, and we're offering a lot of digital ways for you to connect with others. And then of course there are Facebook groups and that sort of thing. Step 5, make a clear written demand that your insurance company honor the promises that were made to put you back where you were before the loss. Be the squeaky wheel, be the speak up, we call it. Go up the chain of command at the insurance company. Try to get to the highest level decision maker you can. Letting them know that you're underinsured through no fault of your own. Tell them the exact amounts by which you are underinsured. Provide them with whatever documentation you can get your hands on. Best practices, and this is just for self-help. This is not if you have, you know, this is before you get to somebody like Ben. Keep the communication professional, be concise, use good grammar and punctuation. Cite to things the insurer did wrong when adjusting your claim. We're going to talk about that a little bit more, Ben, in terms of when we get to talking about leverage, you know, how you kind of position yourself to get the insurance company to do what you want. And now this is a tough one. If your insurer responds by sending you a written questionnaire with questions that get at how your limits were set, see step 6. So before we get to step 6, I'm going to show you an example. This is a questionnaire that I believe State Farm sent to a lot of the people who lost their homes in the 2017 fires to get as a way of finding out, teasing out their facts and whether they had it he said, she said, or whether there really were communications and meetings that would support your claim for reformation. And step 6, which is if you get one of those questionnaires, we strongly recommend that you consult with an experienced policyholder attorney, ideally before giving an interview or giving a recorded statement or being examined under oath or answering that questionnaire. It's just one of the few areas where we really encourage people to get some input from a lawyer that works in this area. It makes a big difference. So you
Amy,
heard,
if I can just interject.
sure, yeah, you want to go
The
back
questions that are posed in that sort of
oh,
questionnaire,
sure.
they are not random questions. Those are questions that are tied to specific cases, so that if they get the kind of answer that they're looking for, they can basically tick off the box that they can establish this defense or that defense. And it may not appear that way when one is looking at these questions. So again, I think that your suggestion that these questions be looked at seriously and that a lawyer assist is a great idea, because sometimes these cases can be won or lost on the basis of a simple answer. And by the way, my counsel to every client is be 100% absolutely truthful, accurate, and honest. You're never going to get anywhere by exaggerating or by trying to get something more than what you're entitled to as far as what your house was before it burned down or those sorts of things. It is the best policy in the world to continue to be honest and accurate, but sometimes have a little bit of help from a lawyer that can allow you to have the questions answered accurately, but in a manner that doesn't have some negative consequences.
Yeah. So how would you imagine an insurer using somebody's answers to something like this? How would that manifest or show?
Well, I think the following is a pretty good example. Whether or not an insurance agent has a duty to determine the amount of coverage is often going to be, like you said, he said, she said. If they come back and say, well, okay, so we had this discussion and I told you, based on the computer, you should get $442,000 of coverage. And you said on this very recording, well, that sounds good, or yes, you agreed to that, didn't you? And one could say, well, I agreed with what you were saying, or I agreed with what the computer said was the amount, but I'm not an expert in homeowner valuation or home rebuilding valuation. And it turns out it costs $750,000. Now, I didn't know that your computer sets the rebuild cost at $232 a foot. And I've come to find out that you knew that the costs in my area were $450 a foot. So if the simple question is asked, did you agree to this? It's almost like there's going to be summary judgment granted against you down the road. But if you say, I agreed with what you told me the computer said, and yes, I received this declaration that said this is my limit, but you didn't tell me it wasn't enough. That's again, and if you do this without a lawyer at the outset, they're going to waive this in front of the court when they're trying to move for summary judgment to stop you from being able to get to a jury.
Yeah.
And again, honesty is the 100% absolute rule in my book. And but there are ways of explaining things that maybe this question cuts through and doesn't give you the opportunity to explain.
So these are the California standards for estimating replacement value that that the Department of Insurance in California put out, and after a long battle, which I was part of with insurers, saying, well, we can't just go on like this with having 2/3 of people be not have enough insurance. It's really slows recovery. It's upsetting. It's frustrating. So the approach that the department took was they did all kinds of fact finding. They put this list out that that if you're going to replace, if an insurance company is gonna estimate, communicate to a homeowner some information about their dwelling limit, it's got to be complete, right? The estimate has to include overhead and profit, debris removal, the price of getting an architect's plans, the foundation, etc. So the department wrote these regulations. They put them out there. This was partly an effort to try to solve the underinsurance crisis. And what does the insurance industry do? They filed a lawsuit and they tried to block the regulations from taking effect. Our organization got involved, and it went all the way up through the courts, and the insurers lost and we won, and these standards are in place. Ben, did you use these? Have you used these in your cases? And if so, how?
I've used these in every case that I have done, because the insurance companies, maybe during the pendency of the appeals, in this case that you handled, Amy, or that you were involved with, went on for years and years and years. And finally, in January of 2017, the favorable decision came out. But it's my theory that I'm 2 for 2 on this so far, is that the insurance companies didn't comply with the regs when they were in a state of limbo. Now, maybe some did, maybe some didn't, but there's an obligation to send to the insured within 3 business days the specific breakdowns of the replacement costs that the policy limits were predicated on. And in the cases I've handled, that hasn't been the case. So yes, we have leveraged this substantially. And in fact, let me give just a quick tale on one of the cases. Before I got involved, my clients had spent a year and 4 or 5 months battling the insurance company, and they took the step of going to the California Department of Insurance, filing a complaint without a lawyer, saying, you know, this is not right. We were never told this. We just bought our house for $1,200,000 and we were insured for $332,000. And how on earth could we possibly be covered, you know, if there's a disaster? And that was 6 weeks before the one of the fires in 2017 on October 9, not the Tubbs, but the Atlas fire. They went there, and when I got the case, they couldn't get relief from the insurance company. I did what I try to do is be very, very thorough. I went to the insurance department's website. I plugged in the name of the agent, and she had what was called a justified complaint. And I thought, wait a minute, I've got this case, I've got these clients, I've got this agent who's got a justified complaint. So I said, I want the information. No, that's confidential. You can't get that. The insurance company said, I'm not going to give it to you. I subpoenaed the Department of Insurance, and they eventually produced it. And guess what? It was a complaint and a finding supporting the justified complaint that the insurance company had failed to comply with this very section that you're talking about. And, you know, to me, it's like, okay, this is a great development in our case. There's already been a finding by the regulator that these people didn't do their business properly. So yes, this is very important. And frankly, it's important if folks, you know, before maybe they get a lawyer, if they have a genuine concern, engage the Department of Insurance. They have a complaint process that, you know, they'll help you, maybe not to the extent that you would like. And once you get a lawyer, they stop helping. But in this last case, the finding had already been entered. So excuse me for taking up perhaps more time.
No, absolutely. So it's so funny how we're very synced up here. The next slide is filing a complaint with the Department of Insurance. Reference the CCR, that's the regs that we were just looking at. And this is just a tip for making sure a summary letter is at the top of your file so that the department can sort of get a really clean snapshot of what the issues are that you want them to look at. And you know, just a note here, I understand a lot of people don't like to complain to the Department of Insurance, or they don't even know there is one. But you know, people, I can only bust this myth over and over that filing a complaint with the Department of Insurance really can only help you. It isn't, unless the department, you know, comes back and says you're wrong and the insurance company is right. But if you have a pretty solid argument, it's so important that you go on record and you let the department know that you were underinsured. And because, you know, we're all working together to solve this problem. I shouldn't say all, but the department and us and advocates like Ben, we're all trying to solve the underinsurance problem. So more information is better. So it's free to file a complaint. Your insurance company cannot take any kind of punitive action against you for filing a complaint. So mediation, if you're going to try to go that route for an underinsurance case, again, you really have to be prepared because just throwing words around at your insurance company is not going to scare them. You have to have a very strong case that you are making to get your limits reformed. So again, mediation, if it can be great if you have somebody helping you like Ben, or if you've got a really strong case and strong evidence that that representations were made to you that gave the agent a special duty or different or mistakes were made, just you can try mediation. But the downside of a mediation is that the insurance company may just be using the process to check you out and see what kind of witness you'll be, and they may not be all that serious. You may leave the mediation feeling it was a waste of money. And I know that a lot of the 2017 North Bay wildfire survivors that we worked with, I shouldn't say a lot, but a number of them tried to use the department's mediation program, and they went in without lawyers, and they ended up feeling pretty frustrated. Ben, did your cases go to mediation?
We did in both cases. They didn't settle at either mediation. These are the two specific wildfire cases here. I do a lot of mediations, but these two did not settle. And I'm not at liberty to say what the consequences were, other than to say that the fact that mediation didn't work was a good thing in the end.
Okay. All right. This is a lawsuit that's still pending. This is a class action that was brought. I'm sorry, not a class. It's a multi-plaintiff suit that was brought against USAA on behalf of a number of families, and that case is still pending. And as you can see there, under in number 7 on the right, reformation is one of the remedies that this lawsuit is seeking. This is another one. This was a multi-plaintiff suit that was filed for 2017 wildfire impacted households against CSAA. That case settled confidentially, and I have been trying to get some details, and so far no luck there. There's one particular upcoming clinic that I want to recommend to those of you who are on today's webinar. We have a few minutes to answer some questions, and before we get to the questions, I just want to say that if you either didn't put a question in, or this conversation has really got you thinking, and you want to talk to a lawyer, we do have a pro bono legal clinic coming up on February 11th. I'm going to hit up Ben and see if he wants to volunteer. We have a number of volunteers though, and that's your chance to sit down one-on-one for an hour, virtually, not in person.
Let me answer. I'd be delighted to, and
Awesome.
flattered. Thank you very much, Amy.
No time like the present to just, wrangle another volunteer. So yeah, if you're underinsured and you really want to talk to a lawyer, you got a chance coming up on February 11th, and you register for these events at that uphelp.org. And as I mentioned earlier, we've been hosting survivor to survivor forums, and that's another place for you. It's free. It's pretty informal. And that's a place where you'll meet other people that are walking the path you're on in some way. And we've got trained volunteers that been there, done that, and came out on the other side, as I said earlier, and they're there to give you some guidance as well. So you can use those forums. You can sign up for our clinic. And those are 3 upcoming events. On the Q&A on February 3rd, I don't recommend that for underinsurance questions. For underinsurance questions, I recommend the forums and the clinic, the legal clinic. So Ben, that was kind of the meat of what I had put together. This is some of our past videos for the 2020 survivors, but I wanted to ask you: are there topics that you want that we didn't cover? Pointers you want to offer to the audience? Now's the time before we get to the questions.
Sure. And again, this may look like we have coordinated, but Amy and I haven't coordinated other than trying to agree to do this. And so I'm delighted. First of all, great job, Amy. I think that it's very important for individuals who have suffered, as any victim of wildfire has, to do their best to really try to amass their documents and their information right away, and to be, as I've said, 100% straightforward and honest and consistent. If you get to the point where you need a lawyer, there are any number of great lawyers out there that can help you. There are some lawyers that maybe don't approach the issues in the same way as others do, and perhaps less effectively. But I think that it's important to force insurance companies to answer questions. And one of the ways that you can do that with a lawyer who can guide you is to do what I call a verified complaint. Those are statements under oath that are being made that end up having two effects. One shows that you're serious and that you've done your homework. And second, it forces the insurance company to answer paragraph by paragraph what it is that you're alleging. And it's a great way to get information about what's in their files before you can actually get the documents from them. Another thing to do is to ask for your claim file information that's available to you, and it has to be provided within 15 days by statute. And I use that statute to make sure the insurance company gives the information very early on, very promptly, and they do take that seriously. One of the reasons for doing that ties back to this set of regulations that Amy was so instrumental in having been found enforceable. That's the Code of Regulations 2695 1.83. I think it's significant if insurance companies are required to give the information that is set forth in the reg. If they don't, I like to force them to tell me whether they did or not in the beginning. And I always say in my letters, please provide me the specific documentation that shows that you complied with, Code of Regulations such and such. And I'll get back letters that, have documents, but not that specific information. And I'll write back and say, thank you very much. I appreciate your cooperation here. I note that you have not sent me this. Could you kindly send me this forthwith? And I've never gotten it, which tells me there's a violation of law, which gives you some extra muscle when you're negotiating with the insurance company. Other things to, again, just kind of some practical pointers. I guess it's really important to find out why a particular coverage A was selected. And for those that are less familiar with the coverage A, B, C, or sometimes D, everything plays off of coverage A. If you have $200,000 of coverage A and you have contents coverage under coverage C, it'll be maybe 50% of that. If you have replacement cost or extended replacement cost coverage, sometimes that's 50%, sometimes it's less. There's one insurance company that has 100% extended coverage. That all plays off of coverage A as well. So it's very important to know why coverage A was determined to be what it was. I can say this because it's a matter of public record. In one case, years into my client's efforts to get a reformed policy, and frankly, within a few months of my getting involved, we forced the insurance company to give us certain documentation. And included in that was an email from the agent to her supervisor, a managing director of this company, that said, the least we can do is reform the policy to such and such so they can rebuild their house. I just picked a random number when I chose the coverage A. And that contradicted the insurance company's statement that that the insured had chosen the coverage. That was key. And then when an agent says, I just picked a random number, what more do you need?
Yeah, that's a lawyer's dream or a plaintiff's dream. Well, obviously, like, you've had success in getting insurers to reform policy limits. So I think, we're here to say it's not a cakewalk. You got to, be strategic about it. But Ben, I that's why I asked you to come on, because, it can be done. And you've done it.
Well, thank you. Most of my career, I've been a lawyer for 38 plus years. I'm licensed in a number of states, and I have, for most of my career, done defense work, and it's been satisfying. It's big, complex cases. Lots of wonderful people that were in-house that I've worked with. Lots of great clients that were, in some cases, falsely accused. Most cases, frankly. But I have to tell you, as a lawyer, it is personally so satisfying to help a couple in their 70s who, have lost everything, who break down in tears when they try to figure out how are they going to get through this, and to be able to help them through the darkness and to get to the other side is really professionally and personally very rewarding. And I've had great clients that I've been able to help, and frankly, at this stage of my career, I think it's a nice thing to be able to give back a bit, and that's why I'm delighted to volunteer for your pro bono or to help in any way I can with your great organization here, Amy.
Well, thank you. Really, we're having a love fest here. All right, let's just try to, we're going to blast through as many of these as we can get to. Some of them are not quite suitable for this forum, but we'll do what we can. Have any of the cases you're familiar with, do they pertain to manufactured homes on fixed foundations? I do not know of any in that category. Do you?
I don't either. No.
Okay. And I will note, we have a claim tips for manufactured home owners, and it's tough when you have a policy that depreciates things the way some manufactured and mobile home policies do. But the laws apply equally to you. The protections apply equally. Our home, Zach writes, our home was built in 2017 and cost $512,000. Our policy limits were increased to $311,000 this March after we discussed the new fireplace that was installed with the State Farm Agent's office staff. They used comparables and a computer program to determine policy limits, but never asked for construction costs. Home was lost in the fire. We're now looking at $650,000 to $750,000 to rebuild. This was in Oregon. So you're not an Oregon, I take it you're not an Oregon lawyer.
Several folks in my firm are, but I'm not.
Okay, so I'm going to ask Zach if you can hold that question and actually send it to, Val, I think this is one thing are we able to see these questions after we wrap up?
Yes, we're able to see them.
Okay, so we'll do our best to get an Oregon expert to answer that question. But my fear is there's no law in Oregon at all on this. That's sort of a common answer on Oregon. Very little insurance case law in that state, relatively little. So a lot of things are going to be a first impression type of a situation. In a total loss situation, if the insurance company's own adjuster comes up with a replacement cost in excess of the coverage, is there a ready remedy in requesting an upward adjustment? So this happens pretty often where the adjuster or a builder prepares an estimate that says that the replacement cost is going to be more than the policy limits. That doesn't mean the insurer is going to retroactively reform. It just means you are definitely underinsured. We received the estimate to rebuild our destroyed home, which is over $165,000 above our coverage A limit. We do have about $150,000 remaining in option OL, ordinance or law, for code upgrades. Can we negotiate to receive these funds to help us get closer to what it would cost to rebuild our house? My instinct is you should be able to, especially with the law that's coming, that is just, I think it's taken effect. It's either January of this year or July, that allows you to take buckets of money from and move them towards your rebuild if you need it. So my instinct is yes. I don't know, Ben, if you feel comfortable commenting on this.
I think your instinct is right. Most policies will say that you don't get the code upgrade until you've actually built, rebuilt and expended the money. So they'll often withhold that. But, if you're settling a matter, one can point to that and say, I want that now as part of my rebuild efforts. And that has been successful in my experience.
So I don't know where this this question person lives, but in many areas, your local building department has information that you can access on the common code upgrades that they require. It's typically going to be electrical, foundation, and those kind of elements of a home. We are renters and we moved 16 days before the loss. Our limits have never been raised despite moving to bigger houses, and we didn't receive our new policy due to the timeline. So if you're underinsured on the contents, or you're underinsured on your ALE, this is going to be a tough one if you don't have any communication that you well, I guess you let the insurance company know that you were moving, but if they knew that it was a bigger house, you can certainly take a crack at trying to get your limits increased, but as a renter it might be hard, will be hard. Anything to add there, Ben?
No, I think that's right. They'll say, well, you had a larger house, but does that necessarily mean you had greater contents? Didn't you just move your furniture from one to the other? And you didn't tell us that you bought, a expensive couch or dining room set or whatnot. So it seems like that will be very fact specific.
Yeah. Emmeline asks, is it possible to file a claim with FEMA if you were underinsured for your contents, but don't feel like you have, but say don't have a case to get more money from the insurance company? So certainly, so FEMA offers at least two options for getting money to supplement your insurance. One is if you're income qualified, you can get up to a $33,000 individual assistance grant. And I do know that that they look at how much you got from your insurance. I think it's a little harder if you're trying to if you're only underinsured for your contents as opposed to your dwelling. I think FEMA's not going to care as much about you being underinsured for your stuff as they would if you said you were underinsured on your dwelling. Christopher writes, as a follow-up, do you have any advice on how we should request a transcript of the conversation? Are there any downsides of requesting a transcript? i.e., for example, the insurer believes you may be taking legal action.
Well, to the extent that's directed to me, I think that one should find out what was recorded because it's ultimately going to either influence how the case is handled, and it most likely would come into a court proceeding, assuming that the required disclosures are made. In California, it's not a one-party consent state; it's two-party. In other words, both sides have to recognize that they're being recorded here, unlike other states. So if there's a recording and it hasn't been properly disclosed that the conversation is being recorded, you can exclude that sort of evidence. So it's best to know the good facts and the bad facts. And if you said something on the tape, you may as well know it now, because it'll come back to be an important factor at some point. And it's better to know the facts early on rather than later.
Yeah.
And the insurance company cannot take the retribution or seek to punish you for seeking information from them. I think that in and of itself would be a bad faith practice that most insurance companies recognize. They have to honor their insurance requests for information Although certain information they don't have to turn over unless and until they receive a discovery request in litigation.
So I always worried when I was in private practice, and I still worry when I'm educating consumers, that as soon as the agent knows that they may be being called to account for the fact that you're underinsured, that they're going to destroy their records. Is that just paranoia? Is there is that a real concern?
There are people that are unscrupulous that do that sort of thing. But there are requirements under the insurance code that certain records be kept for, I think, 5 or 7 years. And, in one case that I had where the insurance company claimed that they had sent out the notice that's required under the code of regulations, they said, well, that's our standard practice. I said, great, why don't you give me the letter that you sent? And they couldn't provide it. And when we eventually got the claim file, there's some internal communication that says, was this letter sent out? Oh, yes, of course it was. Can I have a copy of it? Oh, we don't have any record of it ever having been sent out, but that's supposed to be our practice. So the answer is sometimes things are destroyed. That sort of letter wouldn't be destroyed. The smoking guns are generally not the first thing that an insurance company will voluntarily turn over.
Yeah.
So,
is using Zillow adequate to determine coverage?
Happy to address that, because in the case that we actually just settled today, that was set for trial tomorrow, it turns out that the agent went to Zillow, figured out the square footage of the home, plunked that into the computer, and 2.5 years later, after the draft complaint was sent to the insurance company saying, wouldn't you like to mediate this case before we sue you? By the time we got to the deadline 2 days before, they reformed the policy and said, oops, we made a mistake and used the wrong square footage to cover your client's home. Here's an extra $300,000 of coverage, which still wasn't enough because the house was so vastly underinsured. But Zillow is used, and these companies' computers are just tied into whatever database they can use, and they don't do anything other than, okay, this portion of the form's populated now, let's move on to the next thing.
Mm-hmm. Yeah, okay. Somebody asks, what was the first item that Ben said to ask insurers for? Second thing was claim file, but I missed the first.
Yeah, I like to ask for evidence that, at least in California, that the required reconstruction cost to rebuild one's home, that be provided immediately, so you can see what it is that they said it would cost. And then the question is, was that reasonable at the time of the communication, whether it's an initial policy that's being issued, or it's a change in the policy that comes about as a result of additions to the house or improvements. And by the way, that's something, to the extent that folks don't think about doing. It's a very important thing to, if you have any construction of any type, you add a kitchen, or you remodel your kitchen, or you add a room, let your insurance company know on a go-forward basis, because that's they'll say, well, you never told us about this, so we thought you were still living in this 1950s stucco house, and we didn't know that you added all these features, and so we were reasonable. So, but yeah, the fact that insurance companies are required to tell you what the rebuild costs are is a reason for asking for that as one of the first documents.
Okay, so I think we're going to have to wrap up here. We hit the 5:15 mark. So if you're, I'm sorry, there's one last question I can't resist asking you. Paul asks, I asked the adjuster for my phone recording when I bought the insurance 5 months before the loss. I had questioned the amount. He said I couldn't have it and would not consider increasing, I'm sorry, I just jumped here, and would not, come back. He said I couldn't have the recording and would not consider increasing the insurance. He sent me a letter with no reason for the denial. Any comment on that one, Ben?
Yeah, have a lawyer write the same letter on the lawyer's letterhead and see what kind of reaction you get. If they're hiding information from you, that's a sign that their file is not in order and that the amount of coverage that you were provided may be problematic from the insurance company's perspective. But all it takes is the filing of a complaint, and you'll be absolutely guaranteed to get that information. And the question is, does the insurance company want to be sued in order to give you what it's required ultimately to give you? And I think, again, the polite approach is the best way to proceed, especially since some of these letters can end up being in evidence themselves to show, how you were treated. So always take the high road, always be honest and 100% accurate, and politeness, as we've seen, is an important element in discourse here.
Absolutely, absolutely. Very last question, I swear. If you're underinsured, is it a good idea to just go along with while the insurance company does its process to pay out your limits and then seek counsel? That's kind of, I would say, if you're underinsured, you want to kind of start working on solving that as soon as possible, is my general feeling. But certainly in terms of the insurance company calculating what they think your rebuild value is, that's an important part. Would you agree with that, Ben?
I think you need to raise the underinsurance issue as soon as possible, because otherwise someone might say, well, you're concocting this after the fact, or you read some article and now you're saying this. But if it's clear that the amount is not going to be sufficient, and that's usually pretty easy to determine, I think you want to raise that initially and not be concerned that that's going to have them determine that you're entitled to less. After all, they have an obligation to pay you at least what the stated amount is in the declarations page, and they can't not pay you that just because you've made some inquiries about whether they properly set up the insurance policy in the first place. So I would again recommend bring the issues to light so that they can be addressed. And in some instances, I'm sure there are some experienced adjusters who will say, you know what, we've got to do the right thing here. Let's fix this before it's a big problem, before this person gets a lawyer and we end up spending hundreds of thousands of dollars in attorney's fees and potentially face greater exposure.
Absolutely. Jennifer asked, she says her home was appraised a year before the glass fire completely destroyed it. I'm very sorry to hear that, Jennifer. I still have that appraisal to use. Should I bring it up with my agent, even though I have already been paid the maximum on my limit? Well, if you want to pursue a reformation with that, I mean, if the appraisal I suppose if the appraisal just backs up the insurance company's number, it's not going to help you.
Well, it's interesting. Insurance companies repeatedly say it's not the current value of your house that matters; it's the rebuild costs that matters. So they'll say you can't look to appraisals as a basis for the rebuild costs. Well, that's not completely accurate in my experience. The appraisals will show what the market value is for sure, but if it's got a higher market value, it often is going to mean it has superior features, and those are the features that insurance company computers often do not take into consideration. So I think it is very relevant, especially when combined with an estimate from a licensed contractor that says, well, yeah, to rebuild this, and I see what the features are here based on this appraisal, it's going to cost X hundreds of thousands of dollars more than what you were insured for. So I think the two go hand in hand very nicely.
So I think that is all we're going to have time for tonight. But I do, again, I want to thank Ben so much for your very generous legal wisdom, for sharing your practical knowledge. And I want to remind folks that, as you can see here, we've got 2 more opportunities, 3 more, for you to get talk through some of your underinsurance concerns and questions. And then if you have, if you ask questions that didn't get answered because they didn't directly pertain to remedying underinsurance, we do have a Q&A February 3rd where you can ask our staff your questions about valuation disputes, basically anything other than underinsurance. But for more on underinsurance, I would encourage you to participate in one of the 2 forums or both, and then make an appointment to meet with one of our volunteer lawyers. Maybe you'll be lucky and get Ben. But all of them are great. So again, Ben, thank you so much. I want to thank Val Brown on the UP staff. You can't see her, but she's been helping monitor your questions. I want to really wish all of you strength, good night's sleep, and good health, and a safe journey on the road to recovery. We will be with you. We are rooting for you. We are funded through the end of this year. We are not going anywhere. We pivoted to be able to keep bringing you guidance during the COVID phase that we're all in. And I wish you all good night. The recording of tonight's workshop will be available to you in that library, in your 2020 California Wildfires Recovery Library. So Amy Bach signing off, and thank you again, Ben. And
My pleasure. Thank you, Amy.
All right.